Welcome back to Cross Politic. With us today, we've got Josh Craddock.
How about that?
On the line. He's a third-year student at Harvard Law School. His writing has appeared in National Review Online, Public Discourse, The Stream, and Providence Magazine. Between 2011 and 2014, he managed advocacy teams for several nonprofit organizations at the United Nations, promoting life and the family during the negotiations for the Sustainable Development Goals. I don't know how that happens at the United Nations. Oh, my goodness. He lives in Cambridge, Massachusetts with his wife and his two children. Josh, it's great to have you on the show today.
Hey, thanks so much for having me on.
Yeah, so I was sort of laughing as I read your intro, because it says here that you manage several nonprofit organizations at the United Nations promoting life. And I'm thinking to myself, what, they do that? I didn't think they did that in the United Nations. So how did that happen?
Yeah, well, there are several organizations essentially trying to push back on a lot of the things that the United Nations is trying to impose on various countries around the world, which includes abortion. And so our role there was really to push back on that, reminding them that the Universal Declaration of Human Rights in Article 3 says that everyone has a right to life, and reminding them that that includes all human beings, both born and unborn. So that was what I was doing at the UN for a couple of years. Fun experience.
What was the feedback there? The pushback, feedback?
Well, there was a lot of pushback, but we were able to do some great alliance building with several countries, especially in Latin America, a few Eastern European countries, and especially even some African countries, actually, that, were sick and tired of having the UN push this agenda on them and really wanted to assert their own protections for life. So we were able to see some effective things happen.
Now, we found you on tell us the name of it. It's the Harvard Journal for Law?
Yeah, the Harvard Journal of Law and Public Policy.
And you wrote an article there arguing for human rights for the unborn based on the 14th Amendment. How did that happen?
How did it get published on there?
Well, there's a few different journals at Harvard. Thankfully, the Journal of Law and Public Policy is more open to conservative, libertarian, and moderate thought. And, there's a minority of a minority of those thinkers here on campus. And so, in some ways, uphill battle, but thankfully, Harvard Journal of Law and Public Policy is kind of a space for those thoughts to get aired. So I was honored that they selected my article for publication. So
really quickly, give us just a sketch for our listeners who aren't familiar with you or haven't heard of the article. Sketch the thesis of your article.
Yeah, so my argument is simple. It argues that from an original understanding, the 14th Amendment's use of the word person guarantees due process and equal protection rights to all members of the human species within the jurisdictional and geographical limits of the U.S. Constitution. So I argue that that's the case, and then we know that the preborn are members of the human species from the moment of fertilization from science. And so the 14th Amendment, therefore, protects preborn. So if we concede that minor premise that preborn human beings are biological members of the human species, then all you really have to show is that the term person, in its original meaning at the time of the 14th Amendment's adoption, applied to all human beings. So that's what I show in my article.
And so what's the feedback, Ben? I mean, that does seem like fairly straightforward. What's the pushback? What's the feedback? I assume you've gotten some.
Yeah, I've been really amazed by how the article has been received, especially among, I think, more conservative or pro-life individuals, really saying that this is something that they are hearing for the first time. Because I don't know if you guys know this, but Justice Scalia on the Supreme Court, his view was always that if Roe v. Wade were overturned, abortion would just be returned to the states. And yet Scalia is known as being one of the foremost proponents of originalism. And so I was always confused, about why he would take that position. And then when I started researching it, it seems like, perhaps, I don't know, how closely he ever, investigated the original meaning of the 14th Amendment as regards preborn persons. But, in my research, it was pretty clear that these laws that the laws at the time actually were very protective of the unborn, and that it was widely considered that the unborn were considered persons within the meaning of the law.
as part of that. Yeah.
And you note also that even if I think this is in maybe the full white paper that I saw, but even if unborn persons weren't explicitly thought of, if science demonstrates at a later point that they are a member of the human species, in the same way that freedom of speech protects television and the internet, for example, downstream, we would say, well, those are new forms, those are forms of communication. The First Amendment protects those things. Therefore, 14th Amendment protects human life.
Yeah, that's exactly right. Even under an originalist interpretation, some people have made the argument that, freedom of speech might not include, say, internet communication, or the Second Amendment doesn't apply to guns that weren't muskets at the time. But those arguments are really, those arguments are dismissed as being ridiculous. And so in the same way, person, as long as it was understood to include all human beings, all members of the human species, it doesn't really matter what they knew at that time about the science of human development. Now, it turns out that they actually knew quite a bit about the science of human development, because in the 1830s, even they knew that life began at fertilization, and that's when the laws started to change to prohibit abortion as soon as life could be detected. But even if that hadn't been the case, I think my argument still stands.
Well, and also too, Josh, it seems that the irony of this is that if a woman is killed while she's pregnant, the murderer gets judged for 2 deaths, right? So in some sense, this is being applied already.
Double homicide. Double homicide.
Yeah.
Yeah, you think of somebody like Scott Peterson in California after he was convicted of murdering his wife and his unborn child. He was convicted on 2 counts. So yeah, there definitely is some sort of cognitive dissonance in the fact that many states have these fetal homicide laws on the books, and yet treat the unborn as non-persons when it comes to abortion.
Fetal homicide laws in California.
Right.
There's something odd about that. Now,
talk about dissidents.
Yeah. One of the in the Roe v. Wade case, you talk about how Texas was arguing, the state of Texas. Remember, the state of Texas was arguing this. that the fetus was a person.
Gabe's from Texas.
I'm originally from Texas. Yeah, that's right. Can I get an amen? That the fetus is a person. So the state of Texas was actually arguing the fetus was a person within the language, and of course the Supreme Court rejected that conclusion.
The Supreme Court, in fact, they went so far as to say that if personhood could be established, then the case for abortion would collapse. And so those are the words of Justice Blackmun in the Roe v. Wade decision. But and in my article, I go through his analysis of why he thought that the Constitution only used the word person to apply postnatally, and I kind of show why he's relying on logical fallacies to reach that conclusion. So I tease that out in the full article, but really the bottom line is if personhood can be established, the case for abortion collapses. And so then that's what I'm trying to prove in this article.
So I'm interested in kind of, tackling this question that you brought up with Scalia, with the question of states, whether in your view, is there a moral or legal case that you're arguing in terms of we need to argue this on the basis of the 14th Amendment, or is it more of a practical, utilitarian, strategic case that you're trying to make?
So I think my case is just a matter of constitutional interpretation, trying to show that the Constitution does affirmatively protect the unborn. And so, of course, there's really only 2 justices on the Supreme Court right now who are receptive to this sort of originalist argument, and those are Justices Thomas and Gorsuch. So given the fact that only 2 Supreme Court justices are identifiably originalist in their interpretive method, the question I think that you're kind of getting at is what's the path forward here? Is it really only through the Constitution and the 14th Amendment? And I guess my answer to that would be that I think that states obviously retain a primary duty to protect the inalienable rights of human beings within their jurisdictions. And the foremost natural right of a human being is the right to life. So I would say, yes, states absolutely have a responsibility to exercise their powers, their state police powers is what you call them, to prohibit abortion. But I think that all branches of the federal government also have, an ability to speak into this issue and assert protections for the unborn.
So Josh, would you recommend that a governor, he hears this right now and he's like, oh, if that's right in the if that right is in the Constitution, I'm just going to start obeying it right now and make abortion illegal in my state. And he shows up and starts doing that. What advice would you give him? Would you tell him, yeah, absolutely, please go do that? Or would you say, you know what, why don't we wait until we can get this pushed through the Supreme Court first?
Yeah, I think people have been waiting on the Supreme Court and hanging hopes on the Supreme Court for a very long time, and I'm not sure that that's the best thing. I would encourage that, Governor. I think that there's a long tradition both in this country and in the history of the West of something called the principle of the lesser magistrate, and where these lesser magistrates will actually step up and interpose to uphold the rule of law against unjust acts of the judiciary or the executive that go against individuals' natural rights. So I think that there is.
You're starting to sound like a Presbyterian.
Josh, you passed the test. You didn't know this, but we were testing you, Josh. You just passed the test with flying colors. That's good. Very, very, very good. So now we know that you're a true pro-life guy.
So wait, you mentioned that Chief Justice you didn't mention, but that Chief Justice Roberts is not an originalist in that sense.
I think that based on his jurisprudence, I think Justice Roberts and Justice Alito are far more, they give a lot more deference to precedent. And so even if the original meaning of the Constitution was one thing, if there's been many years of precedent going the other way, I think they're more likely to side with the precedent than, say, Justice Thomas or Justice Gorsuch.
Interesting. I've been watching a little bit. I don't know why I do this to myself, but I follow several writers on Slate. You know, Slate is kind of this far lefty, Yeah. But there's this one guy on there who does updates every once in a while on how horrible Trump is for LGBT rights.
Yeah.
And he particularly on his judicial nominations. And I read his articles because I think whatever he thinks is horrible is probably great.
It's encouraging to you.
and this guy thinks that Trump's judicial nominations are just horrible and getting worse.
Yeah, right.
And in fact, yesterday, Jeb Bush tweeted out an article about several new positions that Trump just chose.
Jeb Bush is on Slate?
No, this is different topic. This is Twitter. But a couple guys from Texas,
amen,
that Trump just nominated for positions. Did you see this, Josh?
Yeah, I did see that. I think it was I saw Justice Don Willett of the Texas Supreme Court was one of the nominees for the Fifth Circuit from Texas, and he's a great guy. I got to meet him this past spring, and he actually has a great story about being adopted and a compelling testimony on that.
Wow.
So yeah, I think he'll be a great appointee.
Wow.
So are these appointees for like higher court appointees kind of thing?
I don't know, they like
fill me in.
They're like circuit court judges or something like that.
Yeah, that's right. Yeah, they're on the U.S. Circuit Court.
So
just
how
one level down from the Supreme Court?
How strategic are circuit judges in all this discussion?
Very strategic. Yeah, they're very strategic. I think that they have a lot of say on how the precedent goes and which cases end up at the Supreme Court. And so, these judicial appointments are very important.
Huh.
Okay, so I'm gonna bring us back. I'm gonna bring us back in. That was just a little bit of
a little civics lesson.
Little take a deep breath. All right,
I learned something.
So back to Chocolate's question for you, Josh. So this is one of the things that we've been pressing with some of our Idaho leaders. We hosted a live governor candidates forum just about a month ago. These are Republican candidates for governor in Idaho. We have talked with there's a state senator that we're good friends with that's local here who's been pressing pro-life legislation. But anyways, we one of the things we've been pressing is this whole idea that how about states just start outlawing abortion? because I think there has been this sense of like just putting all the hopes on the Supreme Court, overturn Roe v. Wade, and so on. And we're all in favor of like let's use every possible way. But to the extent that we have some overwhelmingly pro-life states in the union, why not just say no for Idaho? Every member of the human race has the right to be protected. Their life has the right to be protected because God said so, because the Constitution says so, and just pass the law. And then, of course, then the question becomes, now what happens when the feds start sniffing around? They come and they say, no, Roe versus Wade, you can't do that. And what we've been suggesting to these lawmakers is how about you just sit there and smile and not show up to court? Just smile and just say, no, unborn life there's persons, they're people, and no, you can't do abortion in our state, and we're not going to come to court. We're not going to talk to you about it. See you later. What do you think?
Yeah, I mean, I think states and state legislatures certainly should, take these steps to protect the lives of the human beings in their jurisdictions, and that includes the unborn. And so, absolutely, I think you're right. I think states should fulfill their obligation to protect those human beings, and I think they're justified both on moral grounds and on legal grounds under our Constitution. So I think that's basically correct.
And so, kind of what Toby's pushing a little bit is like if the feds come and say you guys have made abortion illegal against our federal laws, we're going to take you to court, and Idaho says we aren't going to show up in court, what happens? What is
I mean, I've been playing too the whole point that like Washington and Colorado, they've legalized marijuana
against federal law.
We've got these other states that have been
sanctuary cities.
Yeah, they're saying we're not going to abide by immigration law. It seems like there's already sort of this precedent being set for states saying on various federal mandates or whatever laws, and now we're not going to do it.
I just appreciate the irony that it's the precedent's being set by liberal agendas.
Right. Yeah. So Josh,
I think that's a great point. Yeah.
But you think that's reasonable for a state to do?
Absolutely. I think states, not only is it reasonable, I think they really have an obligation to do that, and so I would urge your legislators and governor to do just that. As far as not going to court, I think maybe that's a prudential judgment about whether you want to try and litigate the issue or not. But yeah, I think they absolutely have the obligation to start taking these steps.
Josh Craddock, before you go, tell us where we can find your article at, and on second thought, also tell us what is it you want people to do with this article.
Yeah, well, you can find the article at harvard-jlpp.com. So you can find it there. My name is Craddock, Craddock. So if you Google that and JLPP, you'll find it. I also have a shorter version of the article, kind of a Reader's Digest summary on a website called the Public Discourse.
Nice.
So if you can't wade through 30 or 40 pages of the legal footnoted research, you can get the Reader's Digest version there.
I needed that one.
That's helpful.
And then I think as far as what I want to see from this article, I really would love to see state legislators and officials using this and relying on this research. I would like to see litigators in court who are challenging Roe v. Wade and other abortion funding and that sort of thing to rely on this information to start putting it into their briefs, into their cases, and just try and get this information further out there, because I think right now, the furthest people have gone has been to say, well, abortion's not a right under the Constitution. I think we need to go further and actually affirm that based on the history, based on the information that's out there, abortion is actually wrong and unconstitutional under our Constitution.
Wow. So we need to send this to our state legislators. We need to send this to
this
our.
would be great to send Dan Foreman,
our governor.
Yeah, absolutely.
I just hope Harvard lets Josh graduate.
Well, and we gotta get Josh to guest write on Cross Politics.
Oh yes.
Maybe we can get Josh to write us an article for our blog.
That'd be great.
Man.
Great. Hey, Josh, thank you for joining us, brother. We appreciate having you on.
Thank you so much for having me. I appreciate it.
More Cross Politics when we come back.